Thank you, Madam Chairman Blackburn, and thank you, distinguished members of the committee, and thank you for this opportunity for speaking on bioethics in fetal tissue. My name is Patrick Lee. I'm a professor of bioethics at Franciscan University of Steubenville, and I have submitted my written testimony. I'll just give a brief summary of the arguments, some of the arguments there. In Roe v. Wade, Justice Blackmun claimed that the court would not settle the question of whether the fetus is a human being or not. And yet, as a practical matter, the court denied to human fetuses the equal protection of the law, and so treated them as, in fact, outside the class of human beings. In fact, however, as the standard text of embryology, developmental biology, and genetics assert, a human embryo or fetus from conception on is a distinct whole human individual. The evidence for this is quite clear. We know that a human embryo or fetus is a human being, a human organism, in basically the same way we know that a six-week-old infant is a human organism. Looking at a six-week-old infant, we can see that first, she is a distinct being, not a part of a larger organism. She is a complete being, although at an immature level of development, since even though she cannot now perform many of the actions that are typical of human beings, she is growing, she is actively developing herself to the point where she will do so. In a similar way, it is clear that a human embryo or fetus is a distinct being, since she grows in her own distinct direction. She is obviously human, since she has the genetic structure that is characteristics. She has the genetic structure in her cells that is characteristics of humans. And she is a whole human being, as opposed to functionally something that is functionally apart, such as a human cell or human tissue. For unlike a cell or human tissue, she has within her structure, within her genetic and epigenetic structure, all of the internal resources needed to actively develop herself to the mature stage of a human being. This shows that she already is a whole human organism, only at the earliest stage of development. So the same kind of facts that show a six-week-old infant is a human being also show that a human embryo or fetus is a human being, a human organism. And since what we are human organisms, bodily beings, it follows that she is the same kind of being as you or me, only at an earlier stage of her life cycle. Just as you and I once were adolescents, and before that children, and before that infants, so we once were fetuses, and we once were embryos. Moreover, since what makes you and me intrinsically valuable as subjects of rights is what we are, our fundamental nature, it is wrong intentionally to kill us, and it would have been wrong to kill us when we were embryos or fetuses. All human beings, unborn as well as born, no matter at what age or size, are created equal and are endowed by their Creator with fundamental, unalienable rights. Therefore, it is gravely unjust to provide protection of the law to born human beings, but to deny it to unborn human beings. Since what is killed in abortion is a human being, the further act of governmentally funding and endorsing abortion providers is an additional injustice. By subsidizing abortion providers, the government, unlike the court in Roe v. Wade, cannot even make pretense of being neutral on the question of whether what is killed in abortion is a human being. To subsidize and encourage the killing of human fetuses is to presuppose in that act that what is killed in abortion is not a human being. Furthermore, the donation of organs after death requires prior authoritative consent in general, requires authoritative consent from the person who dies, or, if a minor, from her parent. In the case of fetal organs or tissues, parental consent would be required. This seems permissible in the case of spontaneous miscarriages or ectopic pregnancies. However, that is not the case with relying on the consent of the parent of an elective abortion. Parental authority over children is based on the special connection of parents to their children, a connection that creates a special responsibility of parents to their children, a responsibility to care for them and to be devoted to their well-being. Grave abuses of that relationship, or actions indicating that a parent no longer has the child's interest at heart, cause the parent to lose that parental authority. But the choice to have the child killed, even if done in confusion and with mitigated responsibility, is incompatible with a willingness to act in the true interest of the child. Thus, the practice of allowing or encouraging the use of fetal tissue obtained from elective abortions, relying as it does on the mother's consent, treats the bodily parts of the fetus as if they were parts of the woman's body. The practice makes no sense unless the fetus is assumed to be something other than a human being. Therefore, governmental funding of abortion providers and the use of fetal tissue from elective abortions involve profound dehumanization of unborn human beings and are grave injustices.